Hi, my name is Jeremy Unger, and this is John Surico, and we are the co-editors of NYU Local's national section, and today we're going to be talking same-sex marriage.
As you probably know by now, last week the Supreme Court heard the arguments for two landmark cases, U.S. v. Windsor and Hollingsworth v. Perry. Respectfully, the cases question the legality of DOMA and Prop 8.
To help shed light on this issue, we sat down with Christine Harrington, a politics professor at NYU who teaches law and society and civil liberties in CAS.
The biggest constitutional issues really deal with whether states or the national government can restrict marriage as they have been restricted in the Prop 8 situation at the state level, state law, and then the 1996 DOMA, Defense of Marriage Act, which is the federal restriction. So, I mean, that if there's a commonality, it's that both pieces of legislation are instituted by one state and one federal legislature, both of which restrict marriage to same-sex people. In Loving versus Virginia is a Supreme Court case that struck down anti-miscegenation laws in states. There were, I think, 16 states at the time that it was illegal for blacks and whites to marry, people of those races. And that was struck down on grounds very similar to the arguments that are being made in these cases, that there was a recognition of a fundamental right in marriage that could not be interfered with. There was no legitimate reason, no furthering of any state interest at the state level. The issue here, of course, is there some legitimate interest at the federal level with DOMA. So there is law in this area, and that the court has not been the center for making the law. I think more interesting discussion that was going on the court started to come when Cooper referred to the harm of overturning Prop 8 in his view, and for the plaintiffs, was that it's possible this redefinition of marriage would have real-world consequences, he said, that would not advance the interest of marriage as it had traditionally brick-and-mortar been in the state of California. So there was this sense about some harm that was put forward, and very cautiously by Cooper. It was not an out-and-out, homophobic argument. We know this, we know that. He couldn't make that argument because it's not known. In fact, the adverse is if people will accept 5 years worth of research. Marty Lenderman, who does stuff on SCOTUS, the Supreme Court of the United States blog, and he, I think, very helpfully pulled together 5 ways that the opinion might go. The first one, and I don't think this was ranked in any order, but we'll just lay them out. The court could uphold the constitutionality of Proposition 8, saying it was within a reasonable justification for a state to regulate in this regard, and that the harm of it was really insignificant, that all the same economic advantages of marriage were provided by the state of California in the domestic partnership laws. Okay, another one would be the court would conclude the 14th Amendment prohibits states from discriminating against same-sex couples for purposes of marriage, and this could be across the board because it would be viewed as a fundamental right having been abridged. The third position is called the 8-state solution, which is that the court could kind of slow it down by saying once a state has established domestic partnership, it would be stigmatizing for them not to extend the right to get a marriage license. Then there is the California-only position, which is that there is no constitutional justification for withdrawing the right under California's Constitution and basically uphold the Supreme Court decision in California. And then finally, the view is that the court could dismiss the appeal on standing grounds without a majority opinion resolving the merits, but there could be still opinions written in dissent of that in that case, in the case of dismissing it.
Something that about does it for today. Thanks, Christine, for coming in and giving us such key insights into both the DOMA and Prop 8 cases. We're expected to hear the results of both cases in late June or July. Until then, thanks for watching, guys.